If you come into Cohen, Placitella, and Roth with a products liability case, you can expect to sit down with an attorney who will take all the relevant information about your case. Very often the first thing we'll be asking you is, do we still have the product? Do we still have the vehicle? Because what we will do from the outset of the case is to start evaluating your case to see if there's a legitimate claim or not. We'll get the product, we'll have it analyzed, we'll have it looked at, we'll speak to witnesses, we'll take statements from them, and then we'll go to our experts with that information and see whether there's really a defect here that caused certain harm. If there is, then what you can expect is that we will be filing a claim typically against the manufacturer of the product, the designer of the product, and anybody in what's called the chain of delivery of the product to the marketplace. Once a claim is filed on your behalf in a products liability case, the process can take some time. We'll begin with what's called written discovery, where we'll have the other side answer interrogatories, questions that we ask of them, in which they'll have to lay out everything about the product, how it was designed, how it was manufactured, whether there's been any other claims in the past against them because of this product for similar types of injuries, who the people are who are responsible for the product itself. We'll also conduct discovery through documents, where we will demand of the other side that they turn over every relevant document relating to that product, whether it's the design drawings or the plans for that product, the documents of sale of the product, the advertising documents for the product, everything from A to Z that talks about that product, so that we can make sure that we have all the relevant information to bring your claim forward. After that, the case goes into what's called the deposition phase of the case, where we will take oral depositions under oath in front of a court reporter of all the important fact witnesses in the case who saw your injury or saw what happened, and all the corporate representatives of the defendant, so that we can get all the information that we need to move your case forward against the company who's responsible for the injuries. At that point in time, the case goes to the experts. They issue their expert reports. We give the expert reports to the other side. They do the same thing. They have their own experts who they've hired, who produce expert reports and give them to us. Depending upon the jurisdiction of the case, we will then depose their experts under oath to see how their opinions hold up. And at that point, the case is what's called trial ready. We are ready to take your case to trial. Sometimes these cases are resolved before trial through mediation, through arbitration, and through other ways in which we try to obtain a reasonable settlement for your case. But you should always know that at this firm, we only accept a settlement if we think it's the right thing to do in your case. And we are always ready to go to trial to enforce your rights and to make sure that you get what's fair value for your case, considering what happened to you.